Dated, what is the date of the
19
dated 19 to 21. A proposal of the High Court sent by dated 19 to 21. The to the state is directed to be complied with by the state by passing suitable orders in favor of the petitioners within a period of 60 days. Next para. Next sub-para. The aforesaid order is being passed, especially in view of the earlier order. Earlier order passed in similarly placed persons on 28/4/17 in the case of Kishan Pillai and others versus State of MP by P2, which has since been complied with by order
HOP.
by P4
We can have wait to finally.
by the state. Next para. It is made clear that next subpara, it is made clear that if compliance is not made within the next 60 days, then the matter will be posted as POD for compliance before the appropriate bench.
Yeah. Serial number 5 is AG Tiwari. Bhanu Pratap. See which side with us.
What is the objection?
So it is higher. The division bench.
Division
Very
bench.
short.
How is it maintained?
But how does the division bench take a smooth application? But we are challenging as far as the But as my any show this is we haven't challenged, but challenged the penalty on the most by the extra. Because of this was filed into the beginning. So we have filed for the simple. Now, because it was filed with the order has been passed. My inter-court appeal right has been deprived. That is.
So how do you challenge this division bench order before a then division bench?
The issue is in I hadn't challenged the ultravirus of the However, the order passed.
Whatever may be the mistake, your remedy is before the higher court.
But my intra-court appeal right has been. Also have been filed with single. However, it was listed before. Our division might dismiss. If that had been filed with single, but I would have filed it.
Can we consider this kind of a grievance? Please tell us. Under what provision?
There is no provision. What is by those about encounters. So the petition has been dismissed on ground which I hadn't raised with.
Maybe a wrong order, illegal order. The remedy is before the higher court.
There is the issue.
Otherwise, you can file a review. Did he go in for review? Did they go in for review?
I may be getting the liberty of fine.
The registry has raised an objection as to the maintainability of this writ appeal since the order assailed passed by division bench in WP 8057 of 21. Next, the current counsel for the petitioner is unable to satisfy us as regards the fact that this appeal is maintainable. And therefore, petition stands dismissed as not been, this appeal stands dismissed as not been. With liberty to the petitioner to avail all other remedies available in him. Two. All right, you are for 6.
My objection was simply force of not made.
Rakesh Jain, Shri Jain, Shri Rohit Jain, sorry, Shri Rohit Jain appearing for respondent 2-6 has filed an objection. That is IA what?
Yes,
34724 as regards maintainability of this appeal. इसको ऊपर कर दें, इसके बाद में.
Case number 6, the comparative remark now was he is I want 9729. He want to my watch. I will push for the petition. There are structural discrepancies.
Learned counsel Shri
Amber
Amber Mishra at the very outset placed the withdrawal of this petition with liberty to file a properly constituted one. With the aforesaid liberty, petition stands dismissed as
Okay. Case number 7.
has
The incident.
yes.
Merit by Pilati, Sri Gujarat के अलावा कंप्यूटर सेक्टर में वर्तमान में हैंकर with customer disturbing नामक बीमारी से 30% विकलांग महिला इस न्यायालय में महिला में गलत ढंग से आदेश पारित किया बिना दवा पर आदेश पारित कर दिया महिला
आप एक आपका नाम क्या है? आपका कोई वकील साहब नहीं है? आप चाहते हैं क्या कि आपको फ्री लीगल एड के जरिए कोई वकील साहब दे सकते हैं बिना किसी चार्ज के? चाहते हैं आप बहस करेंगे खुद, आगे चल के परेशानी कोई आएगी तो फिर आपको टाइम नहीं दिया जाएगा। अभी आप टाइम ले लें और 8 तारीख को ऐसे बहुत सारे प्रश्न हमको करने पड़ेंगे जिसका जवाब आप शायद नहीं दे पाएंगे कानून में, इसलिए आप एक फ्री लीगल एड से आपको कोई चार्ज नहीं लगेगा। आपके लिए कोई वकील एंगेज कर लें, उनके साथ बैठें, तो इंस्ट्रक्ट करें और फिर मंडे को लगा देते हैं 8 तारीख। नोटिस अभी नहीं करेंगे जब तक सुनेंगे नहीं आप। ठीक है, करिए, बताइए क्या है।
द्वारा मेरा सामान भी करा दी, मैंने कुर्सी पे सब करा दिए। सेवन इसका नाम 45 उसके नाम 45 से 20 से 45 मैं पूजा अंदर कराए थे और थाने गए थे और पूरा सामान भी करवा दिया, उनने लाइसेंस नहीं करते। इससे पेंशन इसके बाद पेंशन क्लेम है कि फोटोग्राफ से लगा लेंगे।
ये ऑर्डर जब हुआ इसमें 30 दिन में कलेक्टर को कोई निर्णय लेने को कहा गया था। क्या निर्णय हुआ है? अभी तक कुछ नहीं हुआ है। यस,
But depends on the challenge with the P5. But for any storm has been cancelled. Was
कैंसल्ड और सस्पेंडेड?
suspended. Now that event has already been over. So are drafted a license from 9/5/2020 to 2008. So this period has already been expired now. Now what he has to apply. Now what he has to give personal education to the exam. Showing him in fact the High Court कलाकार document जो वहाँ पे
ये 2023 में पेश हुई है अपील, तो ये आज क्यों लगी है फर्स्ट टाइम? दिखाई कब से फाइल की?
ये वहाँ पर काम वेंडर काम कम करते डेटा भी ज्यादा करते हैं तो High Court कलाकार
भाई मेरिट्स की बात नहीं हो रही है, 2023 की ये अपील है, ये आज पहली बार आ रही है कोर्ट के साथ, ऐसा क्यों? कोई डिफेक्ट था इसमें? फॉल्ट मिलेगा 1 साल तक? ये अगस्त 23 में पेश करी थी आपने?
14 डिफॉल्ट
ये रिमूव कब क्यों? ये इनका ऑर्डर का अपॉइंटमेंट का ऑर्डर कौन सा है? अपॉइंटमेंट का ऑर्डर कौन सा है?
लाइसेंस मिला था इनको
लाइसेंस का कहाँ है?
पेज नंबर 17
P2
आपकी बात कॉलम देखिए सर हम व्यक्ति दिनांक 9/5/22 से इनके ईमेल को आने के लिए आपको इनको अप्लाई करना पड़ेगा अगर उनको आगे काम बैंकर काम करना है।
ये कलेक्टर ने कोई ऑर्डर नहीं किया है इसमें? स्टेट काउंसिल 30 डेज में कलेक्टर को बोला था डायरेक्टर ने, विल प्लेस इट नेक्स्ट वीक। आप इंस्ट्रक्शन ले लीजिए। आप कहाँ से आते हैं?
और तहसील में जैसे हर तहसील में हर कोर्ट में बहुत लोग बैठते वकील लोग बैठते बाहर से दिल्ली को आते महिला को उन्नीस सलाह देते हैं कोर्ट में जाने के लिए पीछे तो हम बोलो हम भी कोर्ट चला रहा है हम छोटी मोटी को सलाह देते हैं एक बात बोलने वाला हमको ऐसा वकील हम नहीं बोले हमने अपने आके वकील लोग आते हैं महिला वो सब सलाह हाँ बैठने वाले लोगों से लेते स्टाफ मेंबर से लेते सब लेते और बोले यहाँ क्या है स्टेट से लेते महिला उसका हेल्प सलाह
सुनिए, आप 1 मिनट रुक जाइए। चैलेंज हियर is to the order of single bench where the WP was disposed of. WP filed by the appellant was WP filed by the appellant challenging his order of suspension of the license granted for working as notary. Notary थे आप? Sorry, stamp vendor. Stamp vendor. Has been disposed of by directing the collector to follow the principles of natural justice and pass appropriate orders within 30 days as regards cancellation of the license or otherwise. Next one. It is not known from the record whether the collector has passed any order. Next one. The learned counsel for the respondent number 6. However, informs that the notary of stamp vendor was issued in favor of the petitioner, public appellant, was for the period from and thus the cause raised herein has become infructuous. Next one. However, it would be appropriate to find out what decision was taken by the collector pursuant to the order. Next one. State Council is directed to seek instructions in that regard. Just in the week commencing. कब आ सकते हैं आप दोबारा? 15 तारीख को 15 जुलाई. One 377 or same party. There are two separate orders. As prayed for by the learned counsel for appellant, list along with WA 1377 of 23, provided that said WA is defect free. अगर defects है तो नहीं लगेगा. In the next in the week commencing 15th. Let the name of Shri Manish Verma, who appeared for the respondents in the Great Court, be mentioned in the cause list. That you have already supplied, you have said.
Number 9.
Covered by larger bench or not?
Yes.
Larger bench plus 6/3/24/36. On which point?
Because in this case, what had happened, the taking was ordered by the
Okay.
we take matters to the
Here it was a case of wrong fixation and then recovery. Before, how much before return?
Employee retired on superannuated on 31/10/2017, and the recovery order was issued on 18.
In 8/17.
There was also an undertaking burdened by the employer. And
Any which class employee?
he's a class 3 employee.
Yes.
Okay. I mean, it's a function of 55A of the position.
Yes.
Question number 1 is answered by holding that recovery can be effected from the pensionary benefits or from the salary based on undertaking or indemnity bond given by the employee before the benefits, the plan of benefit of the fixation. The question of hardship of the government employee has to be taken into consideration. Firstly, an undertaking given at the stage of payment of the tithe in the fixation of pay or implement the statement cannot be.
Now, what about this last? Last for
I think so I would take that undertaking given by the employee at the time of one of financial benefit of pay. Those undertaking and is therefore not enforced right to the should be
no, no. What about this 35A last 4-5 lines? Read that. Because they've not said that despite the Rafiq Masih, so they fixed I think 1 year before or something. Rafiq Masih में क्या है? Rafiq Masih is quoted here. It is quoted. Recovery from retired employees or employees who are due to retire within 1 year. So that seals your fate. लिखिए that the appeal, writ appeal filed by the state is against the final order dated. By which the Gujarat Sindhi judge has quashed the recovery and directed the recovered amount to be refunded with interest. So, next, pertinently, the recovery was made by an order passed on 18/8/17 against the respondent employee who was a class 4, a respondent class 4 employee, class 3 employee who was due for superannuation on 31/10/17. Next, the learned counsel for the state has relied upon what a larger bench decision or what? Full bench, what? Huh? Judge bench decision on this court in the case of WA. In a bunch of WAs, including WA, 815 state versus where due to cleavage of opinion between different benches, the matter was referred for resolution, and he said three-judge bench passed inter alia passed answered the queries the following manner. The court page 50, 35A, B, C. Next part. The learned counsel for the state submits that an undertaking has undoubtedly been given by the employee at the time of his fixation of his pay. Fixation of pay कब हुआ था? Nineteen 90 sometime in 1990. And therefore it is submitted that the employee is bound by the said undertaking. And therefore the state is entitled to recover the same, recover the excess payment made during the fixation of pay. Next one. After hearing the 11th counsel for the state, it appears that the respondent is protected by the time period prescribed in the case of Rafiq Masih, 2015, volume 4, SCC 334, where the apex court held thus. Report improved order, it's page 17. Quoted. Para 6 May, it's the quoted portion. Para 12 as per Rafiq Masih. 1, 2, 3. Next. From the above, it is evident that no recovery can take place from a mini employee, irrespective of the fact whether undertaking has been given or not. Comma. Within, if such recovery is made within 1 year of the time. Next up. The recovery in the present case would be 18/8/17 when the petitioner was due for retirement, whereas the petitioner was due for retirement 31/10/17. You are the above the present which appeal, having no substance is dismissed as.
Case number state.
As prayed for by 11 council from the state. Just in the next week.
Case number 11, state. The first button. Right. The rate of 9% from the day. And thereafter, interest rate of 15%. The background of the case is that on 6/6/2008, an award was passed acquiring certain land. The petitioner approved the support, and this court indicated the matter. The Senate will decide as to whether the Act of 2013 would be applicable. The collector decided by order dated 17/2016, which was included in the report. The order of the collector was largely different that whether the case could be covered by the Act of 2013 and it was not on account of
Collector said it will be covered by 13 Act. Huh? The award was passed under 13 Act.
That order of the collector was challenged by the petitioner. The time it takes the lordship to then order. Next to WA1.
I did take as far as the second objection is concerned, the order is in relation to one law and not in relation to petitioner. It is admitted fact that the law laid down the without development authority, the judgment in time and not in purpose. Under all generally situated persons will be governed by judgment. It is not the case that the state government case of the state government that the petitioner had taken compensation, therefore no interest is payable in this case. Since the judgment of inbound development authority SHRI is in them, therefore it will be applicable to all farmers whose compensation was not paid in the time or whose compensation was not deposited with the appropriate authority as mentioned in para 119 of Prav 1. The following time not include the copy of the petitioner for their services. Therefore, it is directed that the petitioner will be entitled to payment of interest at the rate of 9% per annum for the time of taking possession, and after 1 year from the date on which the possession is taken, interest at the rate of 15% per annum, and the payment be made by the state government within a period of 1 month from the date of communication of this. Lordship, submission is that in fact, one payment of the compensation was not at all one of the grounds of the petition. The state did not file any reply. In fact, the petition was sealing the order of the collector given applicability of 2015 Act was under consideration. In fact, the fact on the other hand, the actual background of the case is that 23 farmers were covered. Out of 23 farmers were given compensation as back in 2003. Camps were organized, and in the camp, out of remaining 10 farmers, 7 other farmers were given compensation.
We can please read para 4. Para 4 is the finding.
After hearing the learned counsel of the parties and going through the report, I believe that the learned counsel of the respondent has not been able to solve the amount assessed by the land acquisition officer was deposited on or before taking possession of the land. Till the aspect is missing, the collector has committed factual error by passing the input order in as much as the land of 33 farmers were acquired. Then after paying compensation to 23 farmers, 12 farmers would not have been left out as is mentioned in internal page 2 of the collector. The order of the collector SHRI. This reflects collector SHRI has not applied his mind to the bad situation. Accordingly, the order restricted deserves to be set aside and is thereby set aside. We are agreed by the final part wherein interest has been applied. The award has not been set aside. What remains?
Entitled to interest 9%.
9%
And
from the date of taking of possession, 50% from the date after 1 year. And the background is that camps were organized, all the petitioners were noticed, they were asked to called upon to collect the company. They did not avail. We have 5 documents to indicate the same. Page 22 of the report.
yes,
There's not been able to find out that you don't think that the land acquisition authority will deposit on or before taking possession of the land.
where is that? Where is that, Mr. State Council?
Well, if page 22
There is a factual finding given by the single judge. Now you have to show some cogent evidence to establish that the finding is wrong
page 21
of the
of the return.
writ appeal.
Yes, sir.
22.
They were not part of because this was not a ground. This was not a ground in the rectification.
Well, that
This is precisely our ground in the rectification. That this was not a ground in the rectification. That the competition has not been.
God Adjustment Authority judgment in India 2020 and limited my argument to the extent that I am entitled for interest at the rate of 9% for 1 year and thereafter the rate of 15% from the date the possession was taken.
But this was not the ground in the rectification.
That judgment is there, number one.
Page
Very glad that judgment is in ban.
22 onwards, maybe 16 minutes.
And when you are issued this condition also, whether the amount of deposit will be appropriate authority or not. So notices were sent to us.
So did you file any reply?
They tried a reply. They tried a reply. The only ground was taken by the petitioner, the original petitioner.
So the grounds in the petition are at page 6 of the petition. Let us see.
If you order appears to have been passed with the application of mine, therefore I have interpreted. For that reason given by respondent number 3, since the person have accepted the compensation even after coming into the course of the act. Therefore, provisions of section 24(2) of the Act of 2013 will not be applicable for the remaining affected persons with arbitrary, illegal, and unreasonable in the eyes of law. For that, respondent number 2 has failed to appreciate that provision of section 24(2). It is crystal clear that when the amount is not paid, then the whole of the proceedings shall stand lapse, and new proceedings under section under Act of 2013 for acquisition of the land is to be initiated. For that, respondent number 2 has also failed to appreciate that though the award was passed authoritatively, the amount is to be paid for each individual land is deployed. Therefore, reasoning given in order to reject the claim of the petitioner is personal, illegal, and honest. For that, by virtue of section 24(2) of the Act of 2013, the land acquisition proceedings are lapsed in respect of petitioner land. Therefore, it is the respondent, if the respondent wants fresh proceedings are to be initiated under for that the case of the petitioner is covered by the Institute of on other grounds. At this time, when the petition was perhaps filed, the law development authority had not. So at that point of time, the legal position was that in cases where the compensation was not paid, the acquisition proceeding would lapse. However, the fact after coming of the judgment of the government, that issue has been settled. So,
Settle them. By holding what?
I'm holding that the proceedings will not.
Not lapse. If the compensation is not, if the compensation is not paid.
So that was the ground on which the petition was filed.
So you have to show that you have given him intimation. Where is that?
Page 22 onward. These documents could not be brought up before the court because there was no
There was no.
grounds for us. On page 22 onwards, they are
No, the petition was basically that the compensation should be under the new act. The acquisition should be.
the petition was basically to
So it has lapsed.
that the proceedings had
Lapsed.
since the compensation has not.
You should
No.
recalculate under the new act.
Yes, after coming of the judgment of the
Where is that ground? Where is the ground? How would they have responded to that ground if you don't take the ground?
That ground is making to the left of the proceedings.
No, lapse you have said. That was another, that is basic ground that it lapsed and therefore the new act should apply for computing compensation. But that you had not been noticed, compensation was not received. Where is that?
Only when the judgment is the case of the third development of is during the pendency of the case that judgment court. And then now we find it's para 185 of that. About page 1, para 185. Para 1. And 185.
Yes. Yes,
The provision relates to non-payment compensation requested when the collection is prevented from making payment. It is the obligation made under section 31 one to tender the amount and pay unless prevented by contingency to specified in section 31(2). Thus, the deposit has the correlation with the expression payment has not been made, and the provision made stands with section 2014 only. It is in case of non-payment of prevention from payment, compensation is required to be deposited. And the case may be in the reference court or otherwise in the treasury, if permissible. But they,
so did you deposit in the treasury?
they have not deposited the
We have deposited, but we have had plans to take the payment of the compensation. Back at the can.
No, you say that notices were issued, but he did not come forward to
He
receive.
did not, company did not.
So then where was that amount kept which was awarded?
The land acquisition. Road will either come to para 119. The amount of interest. Para 119. This will be,
Yes, yes,
which has been relied by the luggage from the group. Section 32. Not to the- Yes,
so this 9% and 15% is also here.
yes. Section.
So what is wrong with the order?
There is no wrong with the order.
And every judgment is retrospective always. Unless it is made prospective. Is it prospective, this judgment? This IDA judgment is prospective or?
It applies to all the pending cases.
No, unless it is made prospective.
Not being said in the judgment that.
Final order, final paragraph, final paragraph.
I was like come to para, is 393 conclusions of the court. Para 365 onwards.
Yes. Have they said anything about this order being prospective?
Nothing more. 70, the decision rendered in the municipal corporation is overruled. And all the other decisions in which municipal corporation has been approved are also overruled. The decision is in Balaji Nagar Extension Association cannot be kept to be gained. Good law is overruled and the other decisions following the same are also overruled. In a law development of party versus sharing is that. Have to be reviewed. Section 24(2) and whether or have to be read as law as and was not made for consideration. Therefore, the decision cannot prevail in the light of the in view of the appropriate decision, we answer the agenda. Under the provisions of section 24(1)(a), in case the award is not made as on government to complete the bill, as there is no lapse of proceeding. Compensation has to be determined under the provisions of section 1 Act. In case the award has been passed within the window period of 5 years, including the period covered by an executive order of the court, including shall continue as provided under section 24(1)(b) of the 2013 Act under the 1894 as if it has not been repealed. The word or in the section 24 to between possession and compensation to be read as not or else and three lakhs of land acquisition to the beginning depth of land acquisition proceedings under section 24 of the 2013 Act takes place. Yet due to inaction of the person for 5 years to review prior to the commencement of the said act, the possession of the land has not been taken, not
compensation has been paid. In other words, if this possession has been taken, compensation has not been paid, then there
It's
is no debt.
not prospective. It's not made there. It's not been made prospective.
Yes, it has not been made.
Obviously, it is retrospective.
Might be something. The options that the inform them, like the compensation. If that they will not come forward. Thereafter, as per the judgment, the other option is it will not come forward, it will not give the bank, but amount is reverted back to the patient. This is what my law would come to page 20. Of the written.
Yeah.
This is the notice. If the foot of the page is seen, दिनांक उपस्थित होकर मुआवजा राशि प्राप्त की गई राशि प्राप्त की निर्धारित राशि जमा कर. So then again in page number 37, this is an order sheet of the देश किसको की मुआवजा राशि शर्त के साथ सूचित की जाए कि राशि प्राप्त नहीं की गई तो राशि शासन के घर में आरडी के द्वारा जमा कर.
Because I is not been deposited.
Let him complete.
So this indicates that the attempt were made to make the compensation. As far as whether this amount has been deposited in the RD account, I'll ascertain and submit the document to that effect. This account is the account of the treasury. In normal parlance also and in normal course of things also, it is deposited in that.
You were pointing out, Mr. Gupta, to which para of the IDA?
Para 119.
1-1.
Para 119.
Regarding interest. And the other treasury.
Para 185 and para 186. Thereafter, 203 and 226 are also banking.
Smriti, in the backdrop of what has been held by the apex court in the decision of IDA versus Manohar Lal, reported in so and so, especially in para 119 and 185.
185.
185 as regards interest and deposit and the obligation of the state to deposit the amount of compensation in the treasury in case the person aggrieved does not come forward to receive the same from our state council is directed to inform this court as to whether any attempts were made by the state authorities to deposit the amount of compensation due to the respondent in the treasury or not. List new week commencing 22nd July.
Just to get an application seeking confirmation of the don't mention the number of the.
No, this WA is delayed.
There is a delay, they have filed an application. They have filed an application seeking confirmation of.
There is no delay. As per the registry, there is no delay. तो कोविड पीरियड का एडवांटेज मिला ना. Yes. Diwali lunch. Yes.
But the third part.
Senior is not there.
It's not.
क्या नाम है आपका? सौरभ. सौरभ. Pathak. Informed that his arguing counsel is unavailable list after 2 weeks.
Year number 13. Priyanka Mishra. I 6.0.
Any objection?
No, I kindly seek this, but to find a newly constituted proper person, because that will change the election image or petition, whether it will move on.
You want to withdraw this?
I think we don't find a newly proper constituted.
All right. Agree to it. Please for withdrawal at the beginning. Liberty to file a properly constituted.
Why not?
Dismissed with.
Year number 14, the Rajesh Kumar Soni, Arpan Kumar.
We'll come back in 10 minutes.
Chair number 14, Mr. Rajesh Kumar Swami. Patna High
Get the party to the and also take chart. They have appointed after the petitioner matter. That part has not been considered about the government and not been released. Take any in the page number 7. Mine is आपके पास ही मतलब 7390 और हमारे दुनिया है इसको बाद एडमिशन में हुए अभी आ एटीएफ में हुआ मेरी स्कूल है एडमिशन में आप कुछ ये टेबल से नीचे पे मेरा बनाइए इसमें इनको क्वालिटी का नाम देना 2000 में 2001 में 2000 में कॉर्पोरेट को अगला सिस्टम जब तक एडमिशन से एडमिशन वाले को मतलब इनकी जेड़ा आपको काम कर रहे हैं सब के तो आपको जब आपको भी नाम कंसीडर होंगे
What was challenged in the WP?
WP changed by March and after attending the area for the permission March. They have retired to me, madam, in spite of that, they have terminated my services. They have no attending the data. So that has been changed to be considered after second vision of the petitioner. The other will be just 44. And in the period before. We have also seen the primary color no party part.
You worked for how long? Are you accepting notice? 1 and 2. Who is the contesting respondent? 1 and 2. क्या नाम आपका? Rahul Pathak on behalf of Arpan Pawar accepts notice on behalf of the contesting respondent 1 and 2. Next, let notice be issued to respondent P4 and 5 PF within 7 working days. Returnable in 6 weeks. Yes.
Chair number 15, Mr. Prashant Singh Bhatt.
Partly allowed. Which part has been denied? Declined. Which relief has been declined?
क्या पत्र अपील अधिकार स्थापना अधिनियम या प्रति संस्था द्वारा क्या अभ्यर्थी द्वारा अपील समय अवधि में क्या अभ्यर्थी की सेवा योग्य प्रमाण क्या अभ्यर्थी द्वारा यहाँ पर 18 विद्यार्थी और विद्यार्थी के आवेदन पर और पुस्तक के आधार पर बात करने को नहीं होगा क्या प्रार्थी की सेवा अनुमति का आदेश क्या प्रार्थी वेतन को प्राप्त करने का अधिकारी और उसका एक
तो आपका पार्टली अलाउ, पार्टली तो उन्होंने बैक वेजेस डिक्लाइन कर दिए. What is your grievance? Delay कितना था? Termination कब का था? Termination कब का था?
2002 में
केस फाइल कब किया? डिस्प्यूट कब रेज करी थी? कब रेज करा डिस्प्यूट? The counsel for the appellant is not prepared with arguments just after 2 weeks.
You remember 53 for the one.
Petition dismissed. A1. A1 is the order. 11/1/24. You are the employer. What had you challenged in the petition?
The theft of certain in the instrument for the kind of part from the company. We had inquiry on this manner into the company. Such was conducted finding the in which the kept mark on the doctor of the and subsequently a super notice was issued.
No, the court has found that the Labour Court quashed the dismissal order because they found that opportunity was not afforded to him to cross-examine the prosecution witnesses, produce witnesses. Where have you shown that they have?
There are documents that followed manner A line page 31 and 32. He himself is mentioned in the document I do not base the document on any witness. It is into part of the proceeding one. It's 31 and 32.
31
31
of the petition.
of the petition was A9, page 31.
A9.
The guide copy in the memory file.
कहाँ लिखा? Sorry?
Page 31, I want to get.
Yes.
The second line, 3 से कोई भी गवाह या दस्तावेज सूची नहीं देना चाहता.
आगे पढ़िए.
आरोपी द्वारा आरोप लगाए गए कि उनके साथ अपनी भी तरफदारी कुछ अधिकारी होने पुलिस से रोक रहा है, पश्चिम बंगाल से रोक रहा है, इस पर इसकी कोई कंप्लेन भी नहीं है, कोई एफआईआर भी नहीं है। इस पर प्रबंधन के प्रतिनिधि द्वारा यह कहा गया है कि आरोप बेबुनियाद है और किसी गवाह या कर्मचारी प्रतिनिधि को खाने से कोई उच्च अधिकारी नहीं रोक रहा। And the last opportunity was given to him, and subsequently, since he did not wish to produce any document or any of the witness matter, his rights on 14/10/98 subsequent to that, his proceeding was closed and the inquiry report was submitted wherein termination removal from service was awarded. It was challenged. The Labour Court came to the conclusion that no opportunity has been. And the CJIT also performed the order, but there is no opportunity. But we will just appreciate the record with the file, madam.
The learned counsel for the appellant, referring to annexure A9 in the petition, submits that due and sufficient opportunity was that despite affording a due and sufficient opportunity to the workman, the said opportunity was not availed by the workman, and therefore it cannot be said that the impugned order of it was what, dismissal or removal? Removal was vitiated by the vice of violation of principles of natural justice. Next one. Notice PF in days. Within 6 days for him to. Yes. What? करेंगे तो आइएगा. No. Have they filed it? When you receive the notice, you come forward.
I have not received one of what has happened.
When you receive the notice, then you come.
By this order, petition was granted. And that continued manner, the getting stay also application also came, that was also dismissed order and the interim will conclude with the argument.
Meanwhile, operation in effect of the impugned order, dated so and so, passed by the learned senior in so and so shall remain state till the next date. Was this document a part of the?
Part of the repeat. The number 17 sisters.
Item 17. Yes.
Ordered to in regard to sales were executed, and it was the collateral security of loan. Sale was not contemplated in this fund. Then after my lord, the petitioner filed application under 47 for 20 समाज से कमजोर वर्गों कृषि भूमि धारकों को ध्यान देने वालों एक भूमि अपने संबंधी तत्वों से परिवहन तथा मुक्ति अधिनियम रिपोर्ट एसडीओ करें. Subsequent to the filing of this application, the private respondent mutated their name to the property and sold the property to respondent number 3 and 4. The company violates the SDO Korean declared both the sale deed null and void and restored the possession and gave the possession back to the petitioner. The company violates the respondent preferred an appeal to the indicted collector, whereby the collector remitted back the matter to SDO Korean to decide it on merits. Ultimately, my lords, the matter was remitted back to SDO Khurei. Ultimately, my lords, the SDO Khurei gave an observation that because the petitioner has over 92 acres of land, he is not entitled and he does not come under the ambit of the said Adilium. My lords, the apparent error was that because the 92 acres of land was the land of whole family, not his individual property. Finally, my lords, the appeal came to collector, and collector, without any application of mine, upheld the order of dispute. Subsequently, my lords, the petitioner preferred a WP petition before the Honorable Court, whereby this Honorable Court, my lords, kindly come to connection 8 and page 24. Page 27, my lord.
Yes.
But I am reading para number 9. Shri ZM Shah granted counsel for responding in his turn submit that the petitioner has not produced any revenue record to show that whether land is irrigated or unirrigated. Petitioner has not annexed any of the sale deeds. There is no evidence to bring the case within the ambit of provision contained in section 2F, section 2, section F. We point out that transaction was prohibited transaction of loan. I was of the said rule under the Adilium.
Yes.
Kindly first see rule 2 subsection rule C, holder of agricultural land. Where
Yes.
holder of agricultural land in the weaker sections of the people means holder of land used for purpose of agriculture not exceeding 8 hectares of unirrigated land or 4 hectares of irrigated land within the state, whether Bhumi Swami or an occupancy tenant. Now we come to subclause F.
Yes.
Find out the definition of prohibited transaction of loan. Means a transaction in which a lender of money advances loan to holder of agricultural land against security of his interest in land, whether at the time of advancing the loan or at the time thereafter during the currency of the loan in any of the following books. My lords, we currently have a principle of subclause 4 because this case falls under subclause 4. Outright sale of land with or without delivery of possession with a condition incorporated in the sale deed to resell it or repayment of loan. Now, what happened was before the learned or honorable single bench, all the reports were not there. It was prayed before the honorable single bench to call for the records. But the honorable single bench was not inclined to call for the records in writ petition. Subsequently, my lord,
No, this petition was decided at the first instance,
my lord,
first hearing.
no, the petition of
Reply was there.
there was no
No reply.
no reply.
No reply is there in the petition. Reply to the application and the order entry to 9.
There was at the time there was lack of some of the records of the lower collected. Then the petitioner obtained some of the record because the record was very old, about 15 years old. So we have filed a copy of field deed along with Patra, which is by was annexure A1, which categorically shows that the land was unirrigated land, which is the condition of section 2(3) of the said annexure. My lord, kindly come to page annexure A1, page 18. My lord,
Who was for the other side?
my lord, learned senior Mr. Shah, ZM Shah.
How was for the other?
The only reason why the writ petition was dismissed because there was lack of documents which the petitioner could not show before the letter single grant. And some of the documents have even after bringing minor documents and not for the entire record, which category fully shows that the property was unirrigated and less than 8 hectares of 8 hectares. And this is the only condition.
We'll issue notice to the private respondents. I notice private respondents, PF within 7 days. 7 working days. Returnable 6 weeks.
Clear number 18, decision number.
For weeks time. Any reason? Any good reason?
But we record we have
Ah, the fault में तो नहीं. Not counsel for the appellant is not in possession of his file and therefore there is penalty. This after 2 weeks.
Clear number 19, Yamat Gupta.
Both in का delay. Yes, any objection? Delay control. Yes.
Don't be holding back or payment of his gratuity. Maybe payment of gratuity. As per
What is wrong with the order of the single bench? What happened? Controlling authority. Controlling authority said what? For payment of gratuity. Declined.
competent with the competent authority, the legal commissioner has declined on, but the appellate authority, the legal commissioner has allowed the case of the denial.
Hello.
To pay the gratuity. On the ground,
Why was it declined by the controlling authority?
there is no such order. Order. Or the term of decline that the charge sheet has been issued and applicant has been terminated. I think the appellate authority has said that as per the rule 462 of the Payment of Gratuity Act, the gratuity has been completed only to the extent that the loss has been incurred to the bank. But here in the present case, either the respondent bank has not said about any laws with regard to the charges went to him, that in the charge sheet, the laws has been applied. And one of the,
Then there was no financial loss.
there was no fund. And one of the.
What was the charge? That was found true.
That the charges are.
What was the charge?
But the, uh,
Why don't you prepare the case? Then argue.
charges are mentioned by the learned single death in page 35, paragraph 12 of the order.
No, you don't tell us where the charges are. Please tell us what the
charges were.
what was the charge?
आपने डॉक्यूमेंट नहीं दिए, आपने डॉक्यूमेंट फाइल में नहीं, आपके जो वाउचर है वो फाइल में नहीं, तो फाइनेंशियल लॉस का कुछ नहीं। बड़े चार्ज
Financial loss नहीं.
फाइनेंशियल लॉस यानी हमने ब्रेक को
Where is the
नो फाइनेंशियल चार्ज।
where is that finding?
पेज 46
पढ़िए.
paragraph 88 Furthermore, in reply submitted by the respondent bank to show cause notice dated 7/8/2013, by which he was called upon to explain as to why his gratuity may not be forfeited. Only number one had said that since the restitution against dismissal is already supported before the court, therefore the appointed matter is acted against till the restitution is already decided by this court. Accordingly, the director has, after giving a finding as to whether the bank has but the loss or not, petitioner can pass a price. Respondent in his reply to the reply before the ruling authority as well as before the appeal authority, his destination has not said anything about what has been applied by the petitioner.
Where is the order of punishment? Page. Okay. We have the record. The counsel for the appellant is not prepared with arguments. Therefore, pays for examination just after 2 weeks.
Delay
Delay is condoned. कितना 2 दिन का?
serial number 20 with connected matter.
They are commencing day. So if they could be taken after 15 days. My rate of appeal as well as.
Then you pursue the writ appeals first, then come pursue the writ of
Not be correct.
I mean the review petition first. RP number
Party number 3.
3 of 24.
Yesterday we commencing date 17.
8782. Current counsel, the appellant fairly informs that review petition against the same order reviewed therein has been filed by the RP 3 of 24, which is coming up for consideration in the next week. Next month. Thus, a prayer is made for adjournment list after 2 weeks. Huh? It's appeal. You want to keep this pending?
I want both the rate appeals not to.
So what he's saying is that you can't choose 2 forums.
It's reserved to be reviewed. Now, when I will get that review, I will not totally succeed. Next point.
That review can also, the ground of review can be raised in WA also. Why not?
Yes.
Because WA has a larger scope of
But
interference.
whenever we come, they have been saying that this is a mistake happened. But I find the review. With my from Friday, I find review my God. And then this limitation to file restructuring was going. Therefore, I filed. I was pressing for disposal of that. The court was pressed.
We'll take it
No,
about.
of the not, I will.
Bill number 21 is Shashank Upadhyay. Senior Advocate.
Next week कर सकते हैं. We can make it next week. As prayed for us next week.
Bill number 22 is state.
The rate of challenging on directions contained in para 20.24. For the facts like this, not 100 million.
Direction contained in para.
22 and 24.
What is that?
This is the I just need to recall the facts of the case. The respondent of the red petitioner was not the association of right candidates. How they approach the honorable senator seeking a direction that the post earmarked for blind candidates may be without expenses in income. This clause will not have quoted in my memo of the what was the subject matter of challenge before the honorable senator and what they have framed. Will not be direction was for expedited will not filling up of the post earmarked for visually impaired persons. Will not be filed a status report, we filed action taking reports will not so not that state is taking up the matter. The petition has been finally disposed of, fixing a timeline to conclude the exercise. Now, not the submission is not that in para 22 and 24. The honorable single judge has issued certain directions not for prosecution of medical board, for prosecution of authorities, for taking action against the persons who have issued the disability certificate. Para 22 and 24 may guidance. My respective submission will not that this was not the subject matter of the legislation, will not know bidding for there. Required to the effect will not get whether the authorities in compliance of the act are in place or not, will not was before the honorables. But this para 22 and 24 the direction which is issued by the honorable single judge is all already covered by the legislation.
After para 7 straight away we come to para 10 for the improved order.
We are not challenging the order will of direction. The honorable single judge taken into consideration the law may not as to whether
You are referring to para 22, the impugned order. That 22 starts from para 7. But we don't have para 8, page 8 and 9 is missing in this uploaded. Let us see from the hard one. Yes. Yes. Yes.
State will form a district medical board, regional medical board and state level medical board.
कहाँ पढ़ रहे हैं आप?
7 down, page 7 down.
Yeah. Yes.
The state will form a district medical board, regional medical board and state level medical board for determining the disability and will also work out mechanism to fix the responsibility of the team of the specialist. That in any case, variation of more than 5% is found in the certificate by the higher authority.
5% is nowhere here.
But
Where are you reading? Para 7 of this, para 7 of the impugned order.
page 7, para 22 of the impugned order, running page
Acha,
21.
Yes. Yes.
State will form a district medical board, regional medical board and state level medical board for determining the disability. And it will also fix a mechanism to fix the responsibility of the team of specialists that in any case, any variation of more than 5% is found in that certificate by the higher authority, then they shall be responsible for issuing such incorrect certificate and will have to be dealt with in accordance with disciplinary rules in the routine course or by prescribing other methods to discourage issuance of such fraudulent certificates, thereby taking a vested right of deserving candidates in the hands of undeserving. Not my respective submission will not that the issuance of or non-issuance of the disability certificate was not the subject matter of the application. But there was no pleading, no pleading by either of the parties. Now, para 24 में कैंडिडेट से it is directed that there will be a district level committee in district hospital to issue disability certificate which will be examined at the level of division level whereby doctors who are part of the district level committee will not be And separate team will be constituted at the regional level by the regional commissioner for physical examination and verification of disability certificate at district level. And then these two certificates will be verified at the level of government medical college, catering to concerned district and divisions. These exercises will be carried out after selection and before. So my respect to submission, Lord, if you also may kindly have the look of section 56 of the Act of 2016. Then this entire mechanism, the constitutional board, etc., is already in place, which is not in conformity with the directions issued by the Honorable Single Judge. But the Honorable Single Judge, matter was heard and the order was passed. So, in the absence of it, meeting by any of the parties to this effect, this finding which has now come up is a parallel mechanism will not running contrary to the legislative mechanism. This entire issue is provided in the legislation itself.
Where is that?
Now we kindly come to page 23.
Annexure?
This is the extract you are filing.
Annexure?
Annexure P2 not it's the extract of the act. The relevant provision act filing.
P2 of the petition.
It's 8 times. 28 and 29.
Ah, yes.
Certification of specified disabilities. Number 29. Chapter 10 of the Principal Act. The central government shall notify guidelines for the purpose of assessing the extent of specified disability in a person. The appropriate government shall designate persons having requisite qualification and experience as certifying authorities who shall be competent to issue the certificate of disability. The appropriate government shall also notify the jurisdiction within which the terms and conditions subject to which the certifying authority shall perform the certification function. Any person with specified disability may apply in such manner as will be prescribed by the central government to the certifying authority having jurisdiction for issuing the certificate of disability. On receipt of an application under subsection 1, the certifying authority shall assess the disability and concerned person in accordance with the relevant guidelines notified under section 56 and shall, after such assessment as the case may be, issue the certificate of disability to the such person in such form as will be prescribed by the central government. Inform him in writing that he has no specific disability. The certificate of disability issued in the section shall be valid across the country. Then, below section 59, the remedy against grant or non-grant. Then, annexure A3 at page 30, the rules formulated by the state government in exercise of powers under section 1010. But this also provides the entire mechanism in constitution of the authority. The guidelines of the central government are already in place, not that we find on record. In terms of the act, the central government itself then issue guidelines. The authorities are already notified.
What is your grievance?
No, my grievance is not that a parallel mechanism might be prescribed by the
Is it different than the one prescribed in the statute?
Definitely. The act does not provide for this. The state will form a district medical board with para and state level medical.
You saw a copy on the other side. To whom?
Council was there. Council appeared for the instructing council was not Ashok Gupta.
So, his name is there in the cost list. An advance copy has been provided by the state of this appeal, memo of appeal, to SHRI Ashok Gupta. But his name does not reflect in the next part. Let the name of SHRI also reflect in the cost list for the respondent. This next week.
Was not including the British government. Number 23, what channel?
Much. This will go to the other bench.
Yes.
Let this case be taken up on a bench where not a member.
Next week.
आ जाएगा next week आ जाएगा.
Day number 24. Is Bharatiya Punjab.
Alright, pass over.
Day number 25. State से Bikini Yadav.
Yes.
These are the recoveries arising out of the French matter. Number of expeditions came to be disposed of. Capital protection will not be amount of basic benefit will not be. People are working in the body. Not the listing thing. There is delay also.
How much delay is it?
The delay is about 1 second delay. Not because review was filed, not delays from the original. Review was a complete difference. There is no order will not any interim has been granted. Not in that case also there was about 15 minutes.
We'll issue notice on that delay first.
Steam order is already stayed now. I was at also stayed. So on this time was number WA1783.
What is this Lake Singh Yadav's case? What is this Lake Singh Yadav's case?
So it is of the same but not the order is of same date, not the 43 number.
नहीं, हमला क्या है? ये तो बताइए.
But these are the not these are working these are the workmen we're not working on the post of time. People are in progress when we're not in the WRD below. They are claiming the benefit of higher pay scale below which is not objective to them. So this all matter could not this was decided not.
Where is that Thakur versus R.K. Lekra's case? That judgment?
If you were that is also to challenge in these ones, because the numbers I
Where is that?
all bunch of the side not the state is filing appeal. Why don't we issue notice not a link with the bunch of
Let the case. Let the order passed in WP 4413 of 18, so and so versus so and so, on which the impugned order is based, comma, be produced by the state. This next week. Yes. Ah. Permission. At 3:30 we'll take it. Stupid. Not 2:30. 3:30.
Here we come to the solution. But 25 years, we can like figure out. Medical emergency, I think to
Yes. State has no objection. 27. Let's wait for current council for the appellant. List in the when you want.
Next week.
Next week. Yes. Mobile. You provided some musical background to the arguments. So please take care. Yes, yes. But that is, you're filing it today. There's a special bench which is. All right. Have you given a copy to the other side? Huh? To everybody, all other council. You can only file when you give a copy to the other side. You, you have to give that.
for respondents, along with Shri आपका शुभ-
अजीत वर्मा लॉ ऑफिसर
Ajit Verma, law officer, and
जो इसमें देखिए आप इम्प्रूव्ड ऑर्डर में श्री भागेश्वरी
की सूचना से नेक्स्ट अधिकारी को अवगत कराया गया। आरएक्स 1601
गए हूँ। यह कहना भी सही है कि दूसरी फेसबुक आईडी वर्ष 2020 में बनाई
2001-2002. Yes, state 10,000. 10,000 is not even peanuts. इससे ज्यादा तो उनका लिटिगेशन में एक्सपेंस हो गया हो। इसमें कब से कब तक वर्क किया? नंबर 85.1 डेट बताइए। इसमें तो 92 से 99 नहीं 305 भी 308 बताइए। सेम है इसमें भी। और 310
17 है
पहले 25 देखा
ऑर्डर अंडर चैलेंज 17 है
17 में तो होना जो you may I repeat it after winding up of the company madam certain properties of the company were sold and the whatever the amount is recovered was to be distributed under section 529 and 530
OLR 25 में डिसाइड होगा शायद
डिसाइड होगी उसको आपने एप्लीकेशन कर दिया।
अच्छा
फिर उसके बाद एक 17 और 2022 केस
ये पेश होती है
उसमें सिर्फ ऑफिशियल लिक्विडेटर ने ये कहा कि जो आपने हमने जो OLR 25 दी थी जिसको कोर्ट ने अप्रूव किया है उसके अनुसार हमको पेमेंट करने की अनुमति दी थी। तो उसमें अनुमति देने में कोर्ट ने जो OLR 25 जो एक्सेप्ट हो चुकी थी उसको
मॉडिफाई कर दिया उन्होंने कहा कि सिर्फ 20 करोड़ रुपए देना है बस
20 करोड़ में आपत्ति दी है
आपत्ति नहीं है
क्लेम एडजुडिकेट
मतलब ओरिजिनल जो OLR 25 था उसको मॉडिफाई नहीं कर सकते थे ओनली परमिशन ग्रांट कर सकते थे कि सिंगल जज शुड हैव ग्रांटेड द परमिशन दैट्स ऑल रिफ्यूज्ड
it was an execution
एग्जीक्यूशन की भाई कोर्ट से परमिशन लेके हम पेमेंट कर रहे हैं इधर तो मॉडिफाई कर दिया इसको पार्टली अलाउ करके ठीक है नोटिस इश्यू नोटिस ये वापस कर दी है ना ठीक है
45
अरे एक मिनट बुला उनको पहले बुला इधर आइए एक बार आपने बताया था कि इंफ्रास्ट्रक्चर से रिलेटेड केसेस दूसरी डिवीजन बेंच सुनेगी जैसे अपनी जो डिस्ट्रिक्ट कोर्ट बिल्डिंग की केसेस आ रहा है तो कौन सुनेंगे हाँ आपको हमारा शुक्ला जी के बेंच में सुनना पड़ेगा ये बुक एक ही और बाकी की नहीं कहाँ सुन सकता हूँ।
ये वाला बस है, ये स्पेशल मान लिया पहले से ही।
ये और आया ना
years of service,
Right,
he or she will be entitled to pension.
right,
Now, during the pendency of that notice
right,
for voluntary retirement,
right.
rule was amended and 15 year was enhanced to 20 years.
But that was not be retrospectively.
That but he has
Was it
not brought it cannot be retrospective. Yes.
Unless it's mentioned.
Therefore, I said that his petition stands allowed. But now I'm looking for a direct authority on this point. If you can help me.
Yes, we would do that. I mean, the date when the rules were there, it was actually 15 years.
Yes.
Now, he had already submitted his application.
Yes.
Subsequently, there was an amendment. Not making it retrospectively.
But yes, prospectively.
So consequently, on the day when the rule was invoked, it should be.
Yes, that is the logic. That reasoning is there. That reasoning is there.
Right.
I'm looking for a direct authority.
Please give me some time, we'll do that.
Thank you.
Just give me an half an hour, we'll do that.
नहीं कल रख लेते हैं
कल के दे देंगे.
कल के
We'll
लिए
do that. We'll do that.
मैं इसको अभी डिस्पोज ऑफ कर दे रहा हूँ लिखा दूंगा मैं प्रिंसिपल इज वेरी क्लियर इन माय माइंड आई एम ओनली लुकिंग फॉर अ अथॉरिटी टू सपोर्ट दैट प्रिंसिपल
I get that, I get that.
इसीलिए मैंने पहले बोल दिया सरकारी वकील साहब को कि पिटीशन अलाउ है
But as per the para 3 of the additional return, my lords.
क्या कहा एडिशनल रिटर्न में बताइए
The answer respondents will submit that he will not dispute that the petitioner has applied the voluntary retirement 10/3/2006 and period of notice the voluntary retirement was expire on 30/4/2006.
हाँ ठीक है लेकिन नोटिस का पीरियड खत्म होने के पहले अगर आप नियम अमेंड कर देते हैं तो उसमें आपको ये लिखना पड़ेगा कि यह उन नोटिसों पर भी लागू होगा जो कि इस अमेंडमेंट के पहले दिए गए हैं वो आपने नहीं कहा है वो कहाँ है बस
Gazette notification is annexed.
एनेक्शन
This is P5.
जी
P5 page number. Page number 20.
ये लिखा ना
Amendment
हाँ.
from the date of publication.
ये 18/1/7 को नोटिस दिया ब्लॉट्स उसमें स्पेसिफिक लिखा है कि सूचित किया जाता है कि आपके द्वारा 15 बजे सेवक
आपके पास भी कोई जजमेंट हो तो कल दिखा देना
सर
ठीक है चलिए चैम्बर में लिखा दूंगा इसको पिटीशन अलाउड लिख दो उसमें और P5 लिख दो अमेंडमेंट और दो ये कॉपी
My lord, in this case, my lord, the record of deed necessary, my lord. Because my lord, two
रिकॉर्ड इज देयर आपको देखना है कि बहस करना है
मैं सर देख लेता हूँ. I am subsequent counsel, my lord. Two impugn orders are there, my lord.
ठीक है आप देख लीजिए कब करेंगे कल करेंगे अगले हफ्ते करेंगे
सर अगले हफ्ते कर दें.
श्री देवेंद्र कुमार त्रिपाठी सीरियल नंबर 9 is for time to go through the record which culminated in issuance of impugned orders. Record is available with the Advocate General's office. He may approach the office and inspect the record. Matter will be taken up under the same head next week.
सर इसमें एक्चुअली दो थोड़ा सा मैंने जो अभी देखा दो डी हुई डिफरेंट दो इम्प्यून ऑर्डर हैं और एक में ही चैलेंज हो गया तो
रिकॉर्ड देख लीजिए
मैं देख लेता हूँ एक का ही है आई थिंक के पास.
देख लीजिए
जी सर हाँ मोबाइल
मैंने एसोसिएट्स लिखा है वो आएंगे नहीं फिर राहुल चौबे बैठे हुए जी
Lordship Senior will argue in this matter. He is not in town today. Ajay Mishra, sir. So kindly.
इसमें तो मेनन एसोसिएट्स लिखा हुआ है
Sir.
मेनन एसोसिएट्स लिखा हुआ है इसमें तो
Mishra Associate.
सुरेंद्र नहीं मेनन एसोसिएट्स लिखा है इसीलिए तो पूछ रहे हैं
Mr. This is
सीरियल नंबर
Kavind,
10
WP Kavind Holkar.
WP 2320 of 2008.
This is a bunch of matters.
Acha.
There are 10 cases listed today.
Okay.
They are challenging their repatriation orders. My respectful submission is that they have retired. Most of the petitioners have retired.
Huh.
So the petitions, my lord,
बता दीजिए कौन कौन रिटायर होगा वो इन्फ्रक्चुअस कर देते हैं.
Madam, insofar as we have challenged the absorption scheme as well, Madam. So therefore, in those cases where the scheme in itself is called in question, that would not affect the retirement, Madam, because
कब
ultimately.
बहस करेंगे?
As far as the first case is concerned, my lord, that is WP 2320 of 2008. A policy took its birth in 2013, my lord. In the interregnum period, since they were absorbed, then after absorption, they were repatriated. Then by retirement, these were the different type of cases. Now, in this particular case, my lord, we are challenging the scheme of 2013 on different merits, my lords. So this has not been, has it been
yes,
decided?
it has. The coordinate bench has dismissed that case. They have said that they cannot challenge the scheme of absorption because it is in the interest.
It is depending upon that warehousing some.
No. The coordinate bench has dismissed that.
कोऑर्डिनेट बेंच का ऑर्डर
I'll provide the judgment. my lord.
प्रोवाइड मतलब
नहीं, तो पार्टी का
मतलब-
नाम बता दो, कोई 2006 से उसके
Last-
ऊपर बेस बना करके.
नहीं, there's a Supreme Court judgment which
ऑफिस में
says.
नहीं बैठ पा रहे क्या खांडेकर साहब आजकल?
नहीं, my lord, I am aware of the judgment. My lord, it has.
गवर्नमेंट में अवेयर हैं तो अब
That
पॉलिसी से इनको
अरे भाई आप अभी वकील हो, जिस दिन बाबा बन जाओगे उस दिन ये ठीक रहेगा कि आप अवेयर हो, आपने ऐसे हवा में हाथ किया कुछ
it
आ
will be
गया.
taken tomorrow, my lord. I'll bring that judgment.
हाँ.
I'll bring that judgment. my lord.
क्या मैडम क्या? हाँ
The
मतलब जो
scheme, if he says,
he should opt for बाबा का प्रोफेशन जब हाथ
नहीं
में
अभी
उठा
ये
दे.
बाबा बनने में टाइम, उससे पहले हम बन जाएगा, हम पहले हिमालय में हमें पहुंचेगा. Got it. As far as that is concerned, my lord, if it all this has been taken care of, my lord, by the
कल
VIVEK bench,
कल प्रोड्यूस
कल हो जाएगा.
I'll bring.
कल नेक्स्ट वीक नहीं कल.
हाँ कल हो जाएगा.
तो बोलिए वीडियो कॉन्फ्रेंसिंग से आने के लिए.
हाँ, वकील साहब, हाँ मिश्रा जी.
सर अभी सेम साइड में है.
हैं?
अभी तो
इसीलिए-
सेम साइड में है.
हमको डर है कि हमको वो धक्का मारेगा इसीलिए. ओके, ठीक है.
खांडेकर जी कहाँ गए? अगर पॉसिबल हो तो आप मैडम को, चौबे जी को और इनको दोनों को कॉपी उसकी आज शाम को ईमेल कर देना.
I'll do.
चौबे जी का ईमेल एड्रेस ले
जी.
लीजिए और आपका ईमेल एड्रेस ले लीजिए,
I'll do that.
उसको ईमेल कर दीजिएगा तो कल उतना टाइम बच जाएगा.
I'll do that. I'll immediately do.
None for the petitioner. By way of indulgence, matter will be taken up tomorrow. If petitioner counsel fails to appear, petition may be dealt with on either on its own merits or may be dismissed for want of prosecution. 11 तो मेंशन हुआ था ना फाइनल हियरिंग का. तो 8 और 20 चलिए.
Matter pertaining to departmental inquiry, my lords, I'm praying for weeks' time to prepare and finally argue the matter, my lords.
देखिएगा श्री
Aditya Avasthi.
Aditya Avasthi prays for 15 days time to prepare and argue this matter. On his request, matter will be taken up in the week commencing 22 July 2024.
Number 13. Yes, Kumar Sharma.
Lordship, I'm praying for time to call for the records.
None for the petitioner. Shri Dheeraj Tiwari, 100 pen. आप हैं इसमें? 13. Sir, Shri Aditya Veer Singh for the petitioner. Shri Dheeraj Tiwari prays for time to call for the record. Let record be called for within 2 weeks. Let matter remain in list. It will be taken up after 2 weeks. In the week commencing 22 July 2024.
Serial number 14. Serial number 14, the RF again.
This is a case of dismissal from service, my lord.
जी रिकॉर्ड है भी?
The
Record is not available.
कहाँ चला गया?
First,
फाइनल हियरिंग में मैटर लगते हैं, आपके रिकॉर्ड नहीं रहते. श्री उद्यन तिवारी फॉर द पिटिशनर. श्री धीरज तिवारी प्रेस फॉर, वही ऊपर वाला ऑर्डर आप ही थे ना? हाँ, इसको अब 29 जुलाई वाले हफ्ते में कर दीजिएगा. 2 हफ्ते में रिकॉर्ड बुला लेंगे.
lordship,
रिकॉर्ड बुला लीजिएगा, नहीं तो अगली बार बहुत एग्जाम्पलरी कॉस्ट लग जाएगी.
obliged lordship.
week commencing 29th.
29. आपको बाहर तो नहीं आना?
नहीं,
आप अमेरिका कब जाते हैं?
छुट्टी हो.
अच्छा छुट्टी है, ठीक है. मेरे को लगा प्रेसिडेंशियल इलेक्शन के लिए तो नहीं जाएंगे.
वो आपकी परमिशन लेके जाएंगे सर. Obliged.
सपोर्ट करते हैं रिपब्लिकन्स को कि डेमोक्रेट्स को?
In fact,
ठीक है, ठीक है,
the
चलिए,
fact
कोई
is
बात नहीं. चलिए
my
नेक्स्ट
sister is there in America.
केस.
Obliged.
This matter pertains to the claim of regularization of the petitioners. And it was their claim, my lord, that despite the juniors have been regularized in service, they have been left out.
Okay.
This is the second round of litigation.
ओके.
And the first round of litigation, my lords,
एक ही पिटिशनर बचे हैं ना, गोस्वामी साहब?
now one, no, two are there.
एक ही तो बचे. 15 नंबर है ना ये मुकदमा?
15.
हाँ.
There must
अच्छा
be
वो
some
नहीं,
link.
15.1 तो ठीक है.
हाँ, उसमें लिंक पिटिशन.
15 में सिर्फ एक गोस्वामी साहब बचे.
जी.
कौन से विभाग के हैं ये लोग?
He is, my lord, serving
Municipality?
in municipality Sagar.
म्युनिसिपल.
And I am on the short ground, my lord, not going into the factual, deep into the factual
ये
matters.
अभिमन्यु सिंह जी क्या हुआ, तैयार हैं? रिकॉर्ड है?
My lord, I am on the short ground, if lordship permits me to rephrase this. This is the second round of litigation.
जी.
My lord, may kindly have a look at the order which was passed in the previous round of litigation, P2. It reads, my lord, keeping in view the aforesaid
Connector P?
P2, my lord, page 29 is the order.
P2, yes.
P2. Keeping in view the aforesaid, I'm reading, my lord, the operative portion. Keeping in view the aforesaid amendment made in the petitioner, respondents are directed to consider the case of the petitioner to regularize the.
बुलाने दीजिए, स्क्रूटनी कमेटी की रिपोर्ट बुलाने दीजिए.
Now, my lord,
उसके बगैर कुछ होगा नहीं. स्क्रूटनी कमेटी ने जो कॉन्स्टिट्यूट की गई थी, जिसकी रिपोर्ट तो देखें.
my lord, short ground is there. The court directed them to, my lord, the only sole ground my claim was declined, that the posts are not available at the time of consideration.
जी.
The GAD has issued the circular in the 2008, which has been mentioned in this order in the previous round of litigation, that the committee has to take a decision keeping in mind that circular also, which says that even as on the date of consideration, if the posts are available subsequently, then consideration can be made. Overlooking that particular aspect, my lord, the decision is there, my lord, P3.
तो आप ये दिखा दीजिए पोस्ट अवेलेबल थी उस दिन.
हाँ, पोस्ट भी अवेलेबल थी और other reasons, my lord, the expenditure issue was also not there, my lord. They say that the expenditure was exceeding to 65%. It was not. So apparently, my lord, in compliance with these directions, this particular circular was not taken account. And
अभी आपका आदमी आ गया क्या वहां पर?
नहीं,
रिमांड करने से कोई फायदा नहीं है. उनको रिकॉर्ड बुला के मेरिट पे डिसाइड कर लेते हैं. Unless you say that your man is there, तो.
No, not. We are lingering on, my lord. This is
ठीक है. Let record of the screening committee be called for.
Yes.
आप है ना म्युनिसिपल कॉर्पोरेशन के लिए कौन है? आप हैं? आप श्री अभिमन्यु सिंह undertakes to produce the record on or before the next date. Matter will be taken up in the week commencing 15 July 2024. आ जाएगा ना रिकॉर्ड जब तक कि और लंबा चाहिए?
Some more time we can.
22 जुलाई 23 कर दीजिए चलिए.
Well, it's grateful.
Let it remain in list करके.
Serial number 16. Each time saying,
This matter, my lord, this petitioner was not denotified. He was working as Panchayat Secretary, my lord.
हाँ.
Only question was, although the court, my lord, this honorable court has decided, my lord, we have moved an IA. That a notice is to be served, my lord, before denotifying you. So the only question remains, my lord, whether
Whether any notice was issued before denotifying a petitioner from the post of Panchayat Karmi?
That is there.
है?
That is there.
कहाँ है बताइए? बताइए तिवारी साहब.
इसको कल ले लेते लॉर्डशिप, इसको रिकॉर्ड में इंस्पेक्ट करके देख लेते हैं.
और लिखिएगा. So Dheeraj Tiwari placed for some time to verify whether any notice was issued to the petitioner before denotifying him from the post of Panchayat Karmi. Full stop. On his request, matter will be taken up tomorrow. Under the same head.
serial number 17.
Appointment of the petitioner as an
मिनी आंगनवाड़ी कार्यकर्ता. रिकॉर्ड है भैया?
Record is there.
है ना? चलिए बताइए.
appointment of the petitioner as a mini Anganwadi worker
जी.
that has been set aside by the collector, my lord, in
जी.
appeal, and that the
Annexure?
order, annexure P2, my lord.
P2. क्या कहा कलेक्टर साहब ने?
Collector, my lord, he has said, my lord, that although at the time of the selection process, my lord, the documents which has been filed by the respondent number 6 that was showing that he is not the resident of the same village, my lord.
जी.
But subsequently, the documents were filed before the collector. On that basis, my lord, he is seeing that he is the resident of the same village, my lord.
जी.
And as per the merit, my lord, respondent number 6 is having the 58% and the petitioner is having 57%, my lord.
जी. जी.
But the only crux of the case is, my lord, when the selection was done, my lord,
जी.
it was found that clear, my lord, P11 is the report of the, my lord, project officer, which was called at the time
क्या कहती हैं?
of appeal decision, my lord, by the collector. P11, page 45.
जी पढ़िएगा.
न्यायालय कलेक्टर आंगनबाड़ी केंद्र थूतपुरा उन्मुक्त विकास खंड सिहावल ने मिनी आंगनबाड़ी कार्यकर्ता पद पर नियुक्त हो जारी की गई अंतिम सूची.
आपने नाम पढ़ा उसका? दूधपुरा.
धूतपुरा, यस, उन्मुक्त.
नहीं नहीं.
आदेश के विरुद्ध प्रस्तुत अपील में बिंदुवार जवाब भेजने बाबत श्रीमती सुरसत पांड पत्नी इतने में लौट आंगनबाड़ी भूतपुरा उन्मुक्त में मिनी आंगनबाड़ी कार्यकर्ता के पदभेद कुल 10 आवेदन प्राप्त हुए थे. अनंतिम सूची के आधार पर श्रीमती रेखा पांडे को सर्वाधिक 62.5 अंक प्राप्त हुए थे. अनंतिम सूची के आधार पर श्रीमती पूजा पांडे द्वारा यह आपत्ति की गई कि श्रीमती रेखा पांडे
ठीक है. 2009 में इनका नाम है.
Yes.
ये प्रोसेस कब इनिशिएट हुआ था? डेट्स बताइएगा. व्हेन वाज द एडवर्टाइजमेंट इशूड? 2009 की निर्वाचन उसमें जो है इनका नाम है.
Yes.
ठीक है.
Yes. And petitioner was appointed Wide ordered 1/7/2010, my lord.
हाँ, नहीं वो तो ठीक है.
Yes,
Process date which is material is
yes,
as to when the advertisement was issued and what was the last date. If on the last date or on the date of issuance of the advertisement,
yes,
name of the private respondent was mentioned in the election voter list,
yes,
then as per the circular of 2007, she is entitled to be considered as a local resident.
yes,
If that is a subsequent entry, then you will have a case.
yes.
ठीक है, इतना सा बिंदु है. एडवर्टीजमेंट की डेट बताइए.
But,
रिकॉर्ड दीजिएगा वकील साहब.
as per the form alert, that was the last date 1 January 2009 को.
1 जनवरी 2009 की थी लास्ट डेट.
Yes,
अच्छा देख लेते हैं.
ये P3 में है, my lord.
एक मिनट रुक जाइए, एक मिनट रुक जाइए. ये आवेदन ही 17/8/2009 को पेश किए गए लोगों के द्वारा. एक जन सकती
ये
डेट.
P3 में है, my lord. इनका फॉर्म जो भरा गया था उसमें
फॉर्म तो इनका जनवरी नहीं है. 12/8
फॉर्म भरा है 17/8/2009.
17/8 को भरा है.
Yes.
और ये मतदाता सूची किस तारीख की है?
ये 2009 की है, my lord.
9 की 17/8 के पूर्व की है कि बाद की है? बस इतना सा बिंदु है. श्रीमती पूजा पांडे.
Yes,
और सामने वाली का नाम है सुरसुरी पांडे.
yes.
जी. पूजा वाइफ ऑफ मुहिम. है इसमें तो उनका नाम भी है मतदाता सूची में 2009 की।
Kindly see, my lord, the para 4 of the P2S page 21, my lord.
P2, yes.
As
Page
per the
20.
report, my lord, which has been submitted before the collector, my
जी।
lord. Para 4 of
Yes,
page
पढ़िएगा please.
yes, ma'am. अपील की प्रति भेजकर जिला कार्यक्रम अधिकारी महिला एवं बाल विकास सीधी से जवाब सहित अभिलेख मंगाया गया। पत्र क्रमांक 21 इतने इतने सीधी दिनांक 3/1/2011 से जवाब प्रेषित कर लेख किया गया कि मिनी कार्यकर्ता पदभेद कुल 10 आवेदन प्राप्त हुए थे। अनंतिम सूची में श्रीमती रेखा पांडे को सर्वाधिक 62.5 अंक प्राप्त हुए। श्रीमती पूजा पांडे द्वारा यह आपत्ति की गई कि श्रीमती रेखा पांडे एवं सुरसरी पांडे ग्राम उन्मुख कोठार की निवासी हैं। इस अनदर विलेज जिला स्तरीय समिति द्वारा प्रमाण पत्रों के अवलोकन उपरांत यह पाया गया कि रेखा पांडे द्वारा ग्राम भूतपुरा कोठार का निवास प्रमाण पत्र एवं सुरसरी पांडे द्वारा प्रस्तुत फोटो निर्वाचन नामावली 2009 में ग्राम भूतपुरा कोठार के संख्या क्रमांक 231 में सुरसरी अशोक का नाम दर्ज होने के कारण उन्हें स्थान निवासी मान्य न करते हुए सर्वाधिक 57.75 अंक प्राप्त पूजा पांडे को मिनी आंगनबाड़ी कार्यकर्ता पद पर चयनित किए जाने का निर्णय किया गया। मैडम
जी।
हाउ दिस मैडम एज पर द रिकॉर्ड में लॉट दे हैव सबमिटेड द डॉक्यूमेंट फॉर भूतपुरा कोठार दैट वाज अनदर विलेज। मैडम
जी, भूतपुर कोठार इज डेफिनेटली अनदर विलेज।
हाँ यस,
इसीलिए तो रेखा पांडे जो सबसे ज्यादा मेरिटोरियस थी वो बाहर हो गई।
वो बाहर हो गई और
उनका ये लगा हुआ है
और
इसमें लिखा हुआ है, उनका नंबर लिखा हुआ है।
यस मैडम,
शी इज रेसिडेंट ऑफ भूतपुर कोठार।
कोठार यस
जी।
एंड द रेस्पोंडेंट नंबर 6 आल्सो इनकी इसमें नाम 231 पे है सुरसरी अशोक
221
यस पे
देखें एक सेकंड।
भूतपुरा कोठार के संख्या क्रमांक 231 में सुरसरी अशोक का नाम दर्ज होने के कारण
नहीं 221 पे तो रामकली का नाम दर्ज है भूतपुर कोठार में। यही तो नीचे के अधिकारी सब गड़बड़ कर देते हैं। हाँ, यू आर राइट। Petitioner is aggrieved of the order dated 10/12/2012 passed by Collector Seedhi in case number 18/89 bracket में 15 bracket close /2011-12 whereby an appeal filed by the private respondent Srimati Sursuri Pandey has been allowed by the collector holding her to be a local resident of village Dhratpura Unmukt. Full stop. Petitioner, next para. Petitioner's contention is that the findings recorded by the collector are contrary to the record. Full stop. Next para. Original record is produced by Shri Dheeraj Tiwari, which is perused by this court. Full stop. Srimati Sursari Pandey had filed her application for appointment as mini Anganwadi Karyakarta on 17/8/2009. Full stop. Along with the said application, she had enclosed copy of the 5th class mark sheet, 8th class mark sheet, family card, and the voter list. Full stop. It is evident from the family card available on record that Ward number 13, Mohalla Dhratpura, Ghar Kramank 16 Kha is mentioned in the family card. Full stop. It is not mentioned that she is resident of Dhratpura, Unmukt. Full stop. Similarly, in the voter list, name of the village is shown as Dhratpura Kothar, Tehsil Sehawal, District Sindhi, and her name appears at serial number 231. Full stop. This fact, when examined, then it is evident that even in the application form, the private respondent has not mentioned herself to be a resident of Dhratpura Unmukt, but in column 2 she only mentioned herself to be resident of Dhratpura. Full stop. There are two Dhratpuras in Tehsil Sehawal, namely Dhratpura Unmukt and Dhratpura Kotar. Full stop. Voter list demonstrates that Sursari Pandey, wife of Ashok, is resident of Dhratpura Kothar. Full stop. And therefore the collector CD, taking a view contrary to the available documents which were filed by the petitioner on record, cannot be sustained in the eyes of law. Therefore, order of the collector being cryptic and contrary to the record is hereby set aside. Full stop. इसके बाद क्या कमिश्नर क्या भी गए थे क्या?
Yes, my lord. That has also
Accordingly,
the order of collector.
Appellate order passed by the commissioner contained in annexure
P1.
P1
Yes.
is also set aside, being illegal and contrary to the record. Petition is allowed. It is directed that petitioner being a local resident and private respondent being resident of village Dhratpura Kothar and not Dhratpura Unmukt, her appointment is illegal and arbitrary. Full stop. Let necessary steps be taken to grant appointment to the petitioner within 15 days.
She is already working.
So since petitioner is already working, stay is made absolute. Impugned orders are set aside. Original record is given back to the learned government advocate.
Lordship, in the previous matter, the records are not available, so records need
कौन
to
से
be
केस
got.
में?
जिसमें लॉर्डशिप कल इंस्पेक्ट करके और पंचायत कर्मी का शो कॉज
बताइए कौन सा नंबर है?
आइटम 16, उसमें रिकॉर्ड्स अवेलेबल नहीं है द
कल
प्रीवियस.
बुला लीजिएगा. चलिए.
Yes, Milord, in this petition, Milord, I am making the limited prayer only that, Milord, the representation annexure P7H keep pending before the authority, Milord. Page number 37, Milord.
एक मिनट रुकिएगा प्लीज. Rameshwar Thakur, learned counsel for the petitioner through video conferencing. Petitioner is aggrieved of the order whereby, a petitioner is not aggrieved of any particular order but is praying that her representation made to the authorities seeking transfer to Bhopal from Gaurihar district Chhatarpur be directed to be considered. Full stop. Her representation annexure P7 is available on record. Without commenting on merits, 15 दिन 60 दिन, this court has not expressed any opinion on the merits. चलिए.
Obliged.
Figure number 59. Pandey.
My lord, this is a transfer petition.
जी.
Furnished order date annexure P2, page number 20, page number 10.
जी.
My lord, serial number हमारा ट्रांसफर जबलपुर से भोपाल कर दिया गया है. और सिर्फ एनेक्चर A2 हमारे फादर पैरालाइज है, हमने सर्टिफिकेट लगाया हुआ है एनेक्चर P2 11 पेज नंबर 11 पे.
जी, पेज नंबर 11 में.
50% पैरालाइज और सिर्फ हम अकेले पर्सन है, सारी रिस्पॉन्सिबिलिटी करती है हमारी.
क्या हो गया? ये तो 13 का सर्टिफिकेट है।
पैरालाइज 50% लॉर्डशिप।
ठीक है, रिप्रेजेंटेशन कंसीडर करने के लिए बोल देते हैं, इससे ज्यादा कुछ नहीं कर पाएंगे। पिटिशनर इज एग्रीव्ड ऑफ द ट्रांसफर ऑर्डर एनेक्चर P1 dated 20/6/2024 issued by respondent number 1 project director Madhya Pradesh State AIDS Control Committee on the ground that petitioner has been transferred from Jabalpur to Bhopal, but his father, whose disability certificate is available on record as annexure P2, is suffering from 50% disability on account of paralysis. Therefore, it is prayed that petitioner indulgence be shown and petitioner's transfer be interfered with. Next para. Petitioner has already made a representation to the वकील साहब, आप लोगों को कितना सिखाएंगे हम? आदेश पारित किया प्रोजेक्ट ऑफिसर ने। P6 अभ्यावेदन आप दे रहे हैं डीन मेडिकल कॉलेज नेताजी सुभाष चंद्र बोस मेडिकल कॉलेज जबलपुर को।
P2 पे भी हमने दिया हुआ है।
क्या P2 का अभ्यावेदन है? वो तो आपके फादर का मेडिकल डॉक्यूमेंट है।
P3 22 पे P3 पे दिया हुआ है, पेज नंबर 12।
P3 has made a representation P3 7 days 15 days till then if petitioner is not already relieved parties to maintain status quo. This court has not expressed any opinion on the merits. चल
और से बाई भी गवर्नमेंट एम्प्लॉय है, कटंगी में पोस्टेड, उनका भी लगाया हुआ है
जी, उनका भी ट्रांसफर करा देते हैं। बोलिए, बोल देते हैं अतुल जी को, दोनों का हो जाएगा, साथ साथ रहिएगा भोपाल में। ठीक है, चलिए।
नंबर 75 कुमार सिंह।
Whereas petitioner is seeking the annexation of respondent for payment of annual increment of the year of which he has been retired month.
ये 1 जुलाई वाला कर देना। 30 जून 23 को रिटायर हुए हैं। 1 जुलाई वाला कर देना। उसमें जो मैंने ऐड कराया है
Same
वो
order has been passed P2 में।
ताबिश से और उससे लेके ऐड कर लीजिएगा अमित से। चलिए जी।
सीरियल नंबर 70 कुमार गुप्ता।
कब रिटायर हुए?
30 जून में।
हैं?
30 जून में। 30 जून में।
नहीं, रिटायरमेंट कहाँ मालूम पड़ा?
30/6/2021 में।
अच्छा, ये भी वो है इंक्रीमेंट वाला। 30 जून 21, 30 जून 17 और 30 जून 23 रिस्पेक्टिवली। 1 जुलाई 21, 1 जुलाई 17 और 1। चलिए।
सीरियल नंबर 89 तिवारी।
इसमें रिक्वेस्ट रिस्पोंडेंट ने किए सर, इसमें सीनियर काउंसिल एंगेज है। नेक्स्ट वीक के लिए ले लेते हैं। और लास्ट ऑर्डर शीट देखना, उसकी कंप्लायंस भी नहीं की है सर।
ठीक है।
लॉर्डशिप डेथ सर्टिफिकेट ऑलरेडी फाइल्ड है।
ठीक है, तो कल रख लेते हैं इसको। ले आइएगा सीनियर काउंसिल को।
टॉप आपकी लिस्ट करते हैं।
टॉप नहीं, जिस नंबर पे आएगा वो उस नंबर पे करिएगा।
लंच के बाद रुकते नहीं है।
ऐसा नहीं, ये सब नहीं। नहीं, किसी को अच्छा नहीं लगता लंच के बाद काम करना।
नहीं सर, सीनियर आप एज के हिसाब से सर।
नहीं, वीडियो कॉन्फ्रेंसिंग से आए, लंच के बाद वीडियो कॉन्फ्रेंसिंग से आए। सॉरी, ये सब नहीं चलेगा। नहीं तो दूसरा सीनियर एंगेज कर लीजिए। हमारे कोर्ट में ये सब नहीं।
ठीक
जी। श्री उमा शंकर तिवारी फॉर द पिटिशनर, श्री के गौतम फॉर द रिस्पोंडेंट। बाकी सबका नाम डाल लीजिएगा देख के। श्री उमा शंकर तिवारी submits that senior is not available right now. Matter will be taken up tomorrow. List this case tomorrow. It will be taken up as a mention case at 4 PM. चलिए।
नंबर 91।
हाँ मैडम बताइए।
Your Lordship, the issue in this case is that my qualification prevailing on the date of application has been not considered. I passed higher secondary first. Thereafter, I applied for the compassionate appointment. Kindly see, Your Lordship, and this is also the error apparent on the face of the record, Your Lordship.
जी, क्या ऑर्डर है?
Order, your lordship, it is on page number 14, your lordship. And
14
yes,
annexure P1
P1.
क्या कह दिया?
Para 3 first, that the petitioner consent.
आप पहले तो आई नहीं थी, एब्सेंस में तो कोई रिव्यू होता नहीं। आप अगर आएंगे नहीं, हम मेहनत करें, देख के पिटीशन डिसाइड करें।
I'm really sorry about it.
नहीं, you should be sorry.
I couldn't manage. Actually, I got like, there was an important case in Supreme
ठीक है, this case was not important, so there is no ground for review.
case, your lordship. I'm really, I tender my sincere apology, lordship, but kindly hear this matter. My client should not suffer because of my mistake, lordship, and this was my mistake, your lordship. And this is why perhaps this review petition I'm doing pro bono, your lordship. I haven't charged anything for
That
this
is, we are not concerned with it. We are also doing cases pro bono here only.
I'm
चलिए,
my
ये सब ये ग्राउंड हमारे सामने नहीं चलते। आपका केस ये है कि आपको चपरासी के पद पर जो है कंपैशनेट अपॉइंटमेंट दिया गया। अब आप क्या चाहती है, क्योंकि आप क्वालिफाइड हैं, इसलिए जो है आपको जो है क्लास 3 पोस्ट पे कंपैशनेट अपॉइंटमेंट देना चाहिए। ये लॉ जो है हमने लिखी है, आपने पढ़ी, स्टेट ऑफ राजस्थान वर्सेस उमराव सिंह, पढ़ा कि नहीं पढ़ा आपने? क्या लिखा है इसमें? क्या लिखा है इसमें?
seeking upgradation
is not permissible, is not permissible, is not permissible.
No, your lordship, I am challenging the appointment itself because this appointment has been not made in accordance with the law. There are plethora.
So ठीक है, so we'll ask them to dismiss you because you are not satisfied this appointment on the post of peon, and then consider your application.
Your lordship, I have right to challenge my appointment if it is not made in accordance with the law.
Not in a review petition. Sorry, not in a review petition.
There is apparent error on the face of the record.
हम अगर इसमें observation देंगे कि counsel was not present and therefore she has no right to argue, then that will prejudice. नहीं, authority apology is rejected. Apology is rejected. चलिए,
Your lordship, I board on.
टाइम से आना चाहिए, टाइम से आना चाहिए। जबलपुर के लोकल हैं आप, कोई बाहर से, आपने बता दिया बाहर से आए। इसमें वकालतनामे में आपने लिखा है आकांक्षा सिंह, विजयनगर जबलपुर। जब विजयनगर जबलपुर, फिर बाहर से कैसे हो गया? विजयनगर क्या नगर सीमा के बाहर है क्या?
No, your lordship.
वकालतनामा देखिए, आपका खुद का वकालतनामा देखिए, उसमें लिखा है विजयनगर जबलपुर। देखिए ना वकालतनामा, तो देखिए मैडम, कंप्यूटर पे दिखाओ अतुल जी इनको वकालतनामा। सुबह आप कह रही थी आप आउट स्टेशन काउंसिल हैं, वकालतनामे में आप स्वयं लिखती है या कोई और हस्ताक्षर बनाता है आपके वकालतनामे में? इसमें लिखा हुआ है आकांक्षा सिंह MP 2202/2020 विजयनगर जबलपुर। एड्रेस फॉर इफ एनी विजयनगर जबलपुर। ईमेल एड्रेस खाली छोड़ दिया, फिर टेलीफोन नंबर और फिर हस्ताक्षर। इन्होंने भर दिया था क्या? अच्छा, अब एक दूसरे की ओर देखने से तो कुछ होगा नहीं मैडम, अगले केस में अपना भाग्य ट्राई करिएगा। चलिएगा।
Your lordship,
There is no merit in the case. Petitioner has filed this review petition seeking review of order dated 31st January 2023, passed in WP 20431 of 2011. Next para.
cite a case, your lordship.
दीजिए ना, दीजिए केस दीजिए।
Your lordship, this is the case Delhi Jal Board, your lordship.
अगर बताइएगा वकालतनामे में किसी ने किसी दूसरे की राइटिंग है तो उनके खिलाफ फिर फोर्जरी का केस दर्ज करें। अब तो सजा भी बढ़ गई।
Actually, I was not available and it has been done by.
चलिए।
I live in
हाँ।
Delhi, your lordship.
चलिए, अच्छी बात है।
I'm really sorry about it.
नहीं, चलिए, कौन सा पैराग्राफ पढ़ना है बताइए।
I'm the first para only, your lordship.
जी पढ़िए।
As per the settled law, qualification prevailing.
As per the settled law तो पहला पैरा है ही नहीं, फीलिंग एग्रीव्ड से है पहला पैरा। जजमेंट पढ़ रहे हैं ना आप?
जी, जजमेंट पढ़ रही हूँ। ऑपरेटिंग पार्ट, योर लॉर्डशिप।
ऑपरेटिंग पार्ट मतलब फर्स्ट पैरा में ऑपरेटिंग पार्ट कब से आने लगा? अरे मैडम, आप तो हेड नोट नहीं पढ़ा जाता मैडम, जजमेंट हेड नोट से नहीं पढ़े जाते। आप तो दिल्ली से आई हैं, दिल्ली में हम लोग तो तहसील कोर्ट में भी नहीं पढ़ते, हम तो तहसील कोर्ट के वकील हैं, रहे हैं, तहसील में भी हेड नोट से नहीं पढ़ा जाता।
Your Lordship, para number Your Lordship, para number 7.3.
7.3.
Considering the educational qualification shall be the date on which the application for compassionate appointment was considered. See, Your Lordship, page number.
Madam, why did you accept the appointment? The only question is, all these questions would have been available to you had you refused to accept appointment on the post of peon.
And I'm the eldest son in my family.
Yes.
Entire family is saying ki accept whatever you are getting. But
Ji.
I saw in the department that the other people who were also 12th passed and their parents, their father was also in the same post, class 3. They all were given class 3
कब
post.
मालूम पड़ा आपको ये?
Lordship.
कब मालूम पड़ा आपको ये?
This is something very arbitrary.
मैं कब मालूम पड़ा? आर्बिट्ररी तो है ही मैडम।
Just next year, Your Lordship, I got appointment in 2010
हाँ.
and I got to know about all these things in 2011.
Okay.
Then the petitioner asked the department ki were there vacancies any on the class 3? There were vacancies. Totally qualified, though I was not given. So this is something arbitrary. This is
Achha.
something not in accordance with the law, Your Lordship.
ठीक.
Your
What?
Lordship, kindly see the page number, Your Lordship. Page number 32, Your Lordship.
32 of
32 of the review petition, Your Lordship.
जी. Annexure
Annexure is P6, Your Lordship.
क्या लिखा है इसमें?
Your Lordship, the Abhay Shankar, the applicant Abhay Shankar, he also passed 12th class and his father was also assistant teacher.
जी.
But he was given a class 3 post and the order was issued by the Karyalay Sanyukt Sanchalak Lok Shiksha Vibhag, Rewa. Where is, Your Lordship, on page
आपका अपॉइंटमेंट ऑर्डर किसने जारी किया है?
कलेक्टर ने किया।
सीधी में ना?
सीधी में, इसको रीवा भेजा तक नहीं।
रीवा भेजने का प्रावधान है क्या?
यस योर लॉर्डशिप, इफ कोई 12th पास है तो उसको हायर अथॉरिटी में भेजा जाए।
सारा आर्गुमेंट लिख लूंगा मैं, जितना आप आर्गुमेंट कर रही है ना।
यस योर लॉर्डशिप, व्हाट वाज द
उसमें दिल्ली में आपकी बेइज्जती होगी।
सेंट टू द रीवा
दिल्ली में
हायर अथॉरिटी।
अच्छा चलिए ये भी लिखा दूंगा मैं। और बताइए this review petition is filed. Please now wait. Begging will not help you. वो ऑर्डर आ गया था, ऑर्डर डेटेड आ गया था सब इतना। Learned counsel for the petitioner placing reliance on annexure P6 submits that facts and circumstances. One Abhay Shankar Mishra was given appointment on a class 3 post as assistant grade 3 on compassionate basis by the Joint Director Public Instructions Rewa Division Rewa, whereas petitioner being the son of assistant teacher posted in Sindhi district was not given appointment on a class 3 post but was given compassionate appointment on the post of peon. Full stop. It is next para. It is submitted by case of the petitioner should have been sent to Rewa if any class 3 post was not available and vacant at CD. Full stop. Next para. After hearing learned counsel, therefore it is prayed that petitioner's appointment of peon be quashed and petitioner be directed to be given compassionate appointment on a class 3 post. Next para. After hearing learned counsel for the petitioner, certain facts are required to be noted. Firstly, petitioner counsel was not available on the date when impugned order was passed. Full stop. Petitioner's counsel claimed that she is an outstation counsel, but her wakalatnama on record shows that she has claimed herself to be resident of Vijayanagar, Jabalpur. Full stop. This wakalatnama is available on record. Therefore, there is no justification for not being available when the matter was taken up for decision. Next pair. Petitioner cannot take advantage of fault of his counsel who failed to appear and assist the court when writ petition was taken up for hearing. Next, as far as plea of sending the matter to Riva is concerned, comma, there is no genesis or basis for such argument, full stop. Admittedly, petitioner's father was working as assistant teacher in district CD and therefore, as per the stipulation in the policy, matter was considered by the collector CD, full stop. Petitioner was required to demonstrate through record that a class 3 post was available in the district of CD, full stop. This argument that matter should have been referred to Riva to claim parity with annexure P6 is too far-fetched, full stop. Riva being a separate district from CD, comma, there is no provision for sending application for grant of compassionate appointment to any other district, full stop. Thus, petitioner having failed to demonstrate that there was any clear class vacancy available in the cadre of class 3 at CD, comma, petitioner is not entitled to claim any preferential treatment for appointment merely on the basis of his qualification as higher secondary, full stop. Qualification is only indicative and supportive. It does not create any vested right in favor of the petitioner, full stop. Petitioner, after having accepted an appointment on a class 4 post and worked for over 1 year, is stopped from filing this writ petition or review petition in view of the law laid down by Supreme Court in state of Rajasthan versus Umrao Singh 1994 का 6 SCC 560, and therefore when considered there is no illegality in the impugned order calling for review, full stop. Petition fails and is dismissed.
Number 92.
रेवेन्यू मैटर है also.
है?
रेवेन्यू मैटर.
हाँ बताइए ना.
Annexer A2 and A3 has lordship.
हाँ. उसमें क्या लिखा है?
नक्शा है.
हाँ है नक्शा.
नक्शे का बटांक के लिए आया है.
हाँ. एक
तो ये पेज नंबर 20 है लॉर्डशिप.
हाँ. क्या हुआ?
एंसेस्ट्रल प्रॉपर्टी थी.
हाँ.
मेन पार्ट जो खसरा नंबर था वो 51 था.
हाँ.
51 में 4 लोगों का डिवाइजेशन हुआ था क्योंकि एक ही फादर के संतान रहे हैं.
हाँ, हाँ, हाँ.
तो चारों के बटांक हुए हैं.
हाँ.
तो इसमें जो हमने 51/3 के लिए नक्शा बटांक का आवेदन दिया था,
हाँ.
उसको तहसीलदार और एसडीएम
हाँ.
दोनों ने कंसीडर करते हुए
हाँ.
सही कर दिया लॉर्डशिप.
हाँ. फिर
लेकिन जो रिस्पोंडेंट है उनको ये ऑब्जेक्शन था कि हमने मिलजुल कर ये नक्शा बनवाया हुआ है
जी.
जबकि इनका पार्ट देखें आज भी इस खसरे में लॉर्डशिप पेज नंबर 20
नोटिस दिया था तहसीलदार ने पहले बटांकन करने के. 51/3 में आपने बटांकन करा लिया, उसके पहले नोटिस दिया था संबंधित को.
सर इन्होंने ऑब्जेक्शन दिया था.
वकील साहब आपसे जो सवाल पूछना उसका उत्तर दीजिए. Whether notice was served on the parties concerned. हवा में बहस मत करिए.
नहीं,
ये मिसलेनियस पिटीशन है, PIL नहीं है.
लॉर्डशिप काइंडली see the page number P3 annexer P3 page number 27 लॉर्डशिप.
हाँ. क्या लिखा है इसमें?
इसमें
कब्जे के आधार पे बटांक होता है. किसके बीच में लगाया था ये आवेदन?
ये सिंपल आवेदन है.
अरे आवेदन भाई कब्जेदारों के बीच में होगा ना. सारे कब्जेदारी जो हैं वो आवेदन लगाएंगे. कहाँ है वो आवेदन?
ये 27 में है लेकिन एक
अकेला लगा सकता है क्या? फिर बटांक कैसे हो जाएगा?
उस संबंध में ये एनेक्सर
वकील साहब इसको खत्म करते हैं, आपको लिबर्टी देते हैं, सब लोग मिलके फ्रेश आवेदन लगा दीजिए. उसको तहसीलदार डिसाइड करेगा, उससे ज्यादा कुछ नहीं होगा इस मैटर में।
इसमें जो
सीनियर कहाँ गए आपके?
रामेश्वर सिंह,
हाँ, आप ही हैं क्या रामेश्वर सिंह?
नहीं,
हाँ,
I am appearing virtually, my lord, because I
अरे,
am not able to
क्या हो
move.
गया? आप क्या कहाँ चले गए? दिल्ली चले गए क्या?
Sir, accident हो गया तो I am
कहाँ
not
शिफ्ट हो
able.
गए? अच्छा,
जी जी, ठीक है सर, जस्ट
ठीक है ना जी, लिखिएगा। श्री, शुभ नाम बताइए आपका?
रमेश जैन,
रमेश सेन फॉर द पिटिशनर।
जैन लॉर्डशिप,
रमेश जैन फॉर द पिटिशनर, present in person, assisted by Shri Rameshwar Singh Thakur, appearing through video conferencing. Shri Devendra Kumar Tripathi for respondent number 1.
1, 2, 3, madam.
1, 2, 3. After arguing for some time, petitioner's counsel prays for withdrawal of this petition with liberty to file joint application for Batankan of survey number 51/3, which shall be considered by the Tehsildar if a joint application is filed on its own merits after giving opportunity of hearing to all the interested parties. In above terms, petition is disposed of.
Obliged.
95
A short issue is
Yes.
followed by the impugned order 2/11/23. The trial court has refused to frame the additional issue which I sought by filing application under 14(5) CPC matter.
किस ग्राउंड पे मना कर दिया उन्होंने?
ये हमने एडिशनल इशू की एप्लीकेशन इसलिए दी थी कि हमारा जो सूट है वो फॉर डिक्लेरेशन इंजंक्शन है। डिक्लेरेशन दैट आई हैव सॉट इज लाइक दिस, दैट इज अनेक्सर माय लॉर्ड P1 as P1
Issue
is
notice to the respondents on payment of PF per registered post.
नोटिस हो चुका है उसमें, नोटिस हो चुका है,
इसमें हो चुका है नोटिस?
नोटिस हो चुका है, वो अपीयर भी हो गए हैं।
ये कौन है? ये मेंशन केस में आपने सूचना दे दी थी क्या?
हाँ, मैंने सूचना दे दी थी। But even otherwise, my lord, it is
अरे
displayed.
नहीं, देखिए तरीका ये, नॉर्म ये है कि आउट ऑफ टर्न हियरिंग के लिए जो केस करते हैं उसकी सूचना दे दीजिए।
ठीक है।
परसों अगले हफ्ते रख लेते हैं, कर दी सूचना दे के आइएगा।
जी हाँ, ठीक।
ठीक है सब। श्री मुख्तार अहमद for the petitioner fairly submits that intimation could not be given to the opposite party in regard to out of turn hearing. On his request, this case next week.
Serial number 98. Rajesh Kumar Jain.
Lordship, the civil suit was filed by the plaintiffs. Lordship, the order annexure P1 is under challenge. Page 30.
only मैंने respondent
He
number
is the
3 and
contest.
4 मैंने.
Contesting
I
respondent.
am appearing only respondent number 3 and 4.
So now why they want to linger on? Because now matter is, this order was passed on 24/2/2024.
जी,
We filed this MP petition. Notice was issued. He is appearing from last 2 hearings. And Lordship, now the matter is for final hearing and therefore they want to
कब है फाइनल हियरिंग के
सर
लिए?
ये बता रहे हैं कि कल या परसों फाइनल हियरिंग
No, no.
कल लास्ट
एविडेंस के लिए फिक्स है इन्हीं के, लास्ट टाइम इनने समय लिया था।
इन्हीं के एविडेंस के लिए फिक्स है?
सर मैं सिंपल सर इसमें
डिफेंडेंट
हमारी लड़ाई से मेरी लड़ाई सिर्फ इतनी है।
ट्रायल कोर्ट का मैं बता देता हूं।
हाँ, एक मिनट प्लीज आप बताइए, आप बताइए।
बताएं।
डिफेंडेंट नंबर 1 का एविडेंस ओवर हो गया मतलब।
हाँ।
डिफेंडेंट नंबर 3 एंड 4 टू स्टेट है। 3 ने अभी एविडेंस नहीं थी, उनका अवसर डिस्क्लोज कर दिया क्योंकि लिस्टेड केस है वो। इनके एविडेंस के लिए लास्ट हियरिंग
ये डिफेंडेंट नंबर 4 है ये
4 है।
हाँ,
तो इनने लास्ट हियरिंग में भी अपनी गवाही नहीं दी और कल लगा हुआ है।
कल इनकी गवाही के लिए लगा है ना?
जी।
तो सर अब मेरी सुन सर,
हाँ,
क्वेश्चन सिंपल सर इतना है कि एक लैंड इनके फादर ने सेल की,
हाँ,
उस पे हम वी आर द सब्सिक्वेंट परचेसर।
हाँ,
व्हेन दे फाइल्ड द सूट,
हाँ,
इन्होंने सर ये बोला कि दे आर इन पोजीशन ऑफ द लैंड। Subsequently, the person who purchased the land initially from them, he produced a document in 2024. On that basis, they moved an application कि उस डॉक्यूमेंट के बेसिस पे हम अमेंडमेंट करना चाहते हैं। ठीक है, उस डॉक्यूमेंट के बेसिस पे करें। मगर नाउ they are also seeking that if we are not in possession, we should be given a possession. When they specifically says in their plaint कि हम पोजीशन में हैं।
ठीक है, वो ट्रायल कोर्ट देखेगा ना इसमें क्या?
सर ये हमारा ऑब्जेक्शन था और उन्होंने उस ऑब्जेक्शन मेरे आप उसकी देख लें एक बार। वो अमेंडमेंट जो इन्होंने पेज 43 पे एनेक्सर P7 ट्रायल।
They have, he has
सर अब
also
मेरे को
done,
कहने दीजिए।
he has also
done constitutional amendment by that.
कॉन्स्टिट्यूशनल अमेंडमेंट भी हो गया क्या?
My lord, और एविडेंस भी ओवर हो गया
सर सर आप यहाँ पे स्टे नहीं था तो हमारे लिए परेशानी ये थी। अब आप ये
अब
सर
क्या करेंगे?
सर आप एक बार पेज 42 देख लो
दीपक जी, हम सब देख लेंगे, लेकिन मुद्दे की बात समझिए।
सर
अमेंडमेंट हो गया, कॉन्स्टिट्यूशनल अमेंडमेंट हो गया, तो अरे भाई ये साक्ष्य में कल साक्ष्य देके बता दीजिए कि इनका कब्जा नहीं था, इसलिए इनका।
सर जब ये खुद कह रहे हैं हमारा कब्जा और बाद में कहते कब्जा नहीं है।
अरे ठीक है भाई, तो कल आप इनका ये तो सेल्फ डिफीटिंग प्लीडिंग है, आपको इसका फायदा मिल जाएगा। यहाँ क्यों हमसे लिखवाना चाह रहे हैं?
इनने यही बोला है और ये इसी को इनने बोला है और टाइम बार सारी चीजें इनने कॉन्स्टिट्यूशनल अमेंडमेंट
क्योंकि सर ये 12-13 साल बाद ये अमेंडमेंट आ रहा है। जब प्लेन फाइल हुई थी तब नहीं है, तब ये कह रहे हैं कि हम खुद कब्जे में हैं। आप सिर्फ एक बार प्लेन देख लें सर।
हो गया।
आपने प्लेंट में इकरारनामा के बारे में कुछ नहीं लिखा, सेल डीड।
मैं आई एम नॉट डिसाइडिंग योर सिविल सूट। आपका शुभ नाम क्या है वकील
साहब? आई एम नॉट प्लेंटिफ फॉर यू।
क्या?
शैलेश
जैन साहब, हम आपका ये झगड़ा नहीं सुलझा रहे हैं यहाँ पर। 227 की पिटीशन है, कॉन्स्टिट्यूशनल अमेंडमेंट हो गया। ये कल साक्ष्य दीजिए, अपनी साक्ष्य दीजिए, उसमें प्रमाणित करिए कि इनके पास कभी भी कब्जा नहीं था।
खुद ही कह रहे हैं कि बुद्धुल्लक मृत्यु होने के साथ भूमि पर वादिका संयुक्त रूप से मालिक
पढ़िएगा तो ऑर्डर 2 रूल 2 तो पढ़िएगा कि क्या होता है, तो आपको एडवांटेज मिल जाएगा।
अगर ये चीज क्या,
हम कुछ नहीं करेंगे इसमें।
Now this will change the nature of the suit, I said.
ठीक है, चलिए
such a long lapse of time.
चलिए कोई बात नहीं है। क्या करना है, इसको विड्रॉ करिए, कल एविडेंस दीजिए। हमने एक भी ऑब्जर्वेशन कर दिया, वो सूट को प्रेजुडिस कर देगा।
ठीक है सर, ठीक है।
श्री दीपक अवस्थी, after arguing for some time, prays for withdrawal of this petition with liberty to raise all objections before the trial court and the appellate court.
Number 929, Shri Mohanlal Sarma.
Lordship, may kindly see the order dated 2/5/24.
2/5/25.
Lordship, after 10 years, the award, the amount of the award has been.
एक्सप्लेनेशन आ गया क्या कंसर्न डिस्ट्रिक्ट जज का? ये
नहीं आया लॉर्डशिप। इसमें लॉर्डशिप एक्चुअली
एक मिनट रुक जाइए, ऐसा कैसे नहीं आएगा? When it's order of High Court, she is bound to follow it. एमएसडी जज का एक्सप्लेनेशन आ गया, दिखाइएगा क्या लिखती हैं। हाँ ठीक है। देखिएगा, थर्ड, there is explanation given by the member Motor Accident Claims Tribunal Burhanpur, namely Srimati Ashita Shrivastava, who has admitted her mistake by DO dated 22/5/2024 bearing number nil/D.J.Steno/2024 addressed to the principal registrar within bracket judicial bracket close, admitting that while passing order dated 20/2/2024 because of loss of vision, ब्रैकेट में लिखिएगा दृष्टिलोप। दृष्टिलोप क्या होता है? टू ओवरसाइट। दृष्टिलोप मतलब ओवरसाइट हो गया ना। देखो भाई, दृष्टिलोप का अंग्रेजी में डिक्शनरी में, she missed the date of the award and passed the said order for which she has no mala fight, full stop. She has assured that such mistake shall not be committed again, full stop. It is prima facie admission of guilt by Srimati Ashita Shrivastava that she has not acted bona fidely and has worked in a very casual manner, full stop. Interim order is made absolute, full stop. Impugned order dated 13/2/2024 is hereby set aside. Matter is remitted to the tribunal to do the needful. Petition is allowed and disposed of. Chali. This DO be kept in her service book.
Loss of vision.
Loss
of vision.
क्या हो गया?
दृष्टि
लिख लेना भैया, दृष्टि लोक को। हाँ, this DO be kept in her service book. चलिए।
मिलाडी मामला ये
सर्विस बुक में मत रख, मर जाएगी।
सेल्समैन के दुकान का प्राधिकार समाप्त कर दिया गया है।
और क्या कर दिया गया?
सेल्समैन ये किया था 30/10/92 को एज ए सेल्समैन।
हाँ, फिर
और
तो 23 का आदेश है वकील साहब, आज क्यों आए?
नहीं मिलाड ये आज
Reply has been filed.
रिप्लाई आ गया, सुनेंगे
जी,
इसको। अब तो टाइम हो गया कोर्ट का। प्लीडिंग्स आर कंप्लीट, केस इज टू बी हर्ड द वीक कमेंसिंग 5 अगस्त 2024।
लंबा हो गया मिलाड।
क्या
थोड़ा सा पहले हो जाए तो अच्छा रहेगा।
यार, हम लोग काम नहीं करते, अब फिर इतना बोझ कैसे सह पाएंगे?
प्लीज
बताइए श्रुति जी।
सर, एक 73 पर लगा हुआ है, वो 1 जुलाई वाले इंक्रीमेंट का केस है। अगर तो
73 कर देना भाई, 1 जुलाई देख के, आशीष श्रुति नाम डाल के जी। देखना भाई, एक सुनो भाई, ये 79 भी चेक करना, ये भी वही लग रहा है। 79 की फाइल दीजिएगा, एक्शन 79। जून 15 को रिटायर हुए, 1 जुलाई को है ना इंक्रीमेंट है। 79 भी कर दीजिए। चलिए, इफ द नॉर्मल डेट को सब में लिखिए।
75 भी वही है सर।
75 तो हो गया।
जी सर, oblige।